Well, welcome everybody. My name is Tony Saramatis. I'm with Truly Wow. We are ARA's marketing and communications partner, and I would like to welcome you to ARA's Continuing Education Series webinar for July. Just a couple of real quick housekeeping items before I hand things over to Dave Kennedy to introduce our presenters. First, we have a lot of folks on the webinar today, which is great. So we put everybody on mute. And we definitely encourage you to ask questions, and there's going to be a dedicated Q&A session at the end of the webinar. There's a Q&A button at the bottom of your screen. Use this button for any questions, and we'll get to them in the order that they came in during the Q&A portion at the end. So with that, I'm going to hand things over to Mr. Dave Kennedy to kick us off. Take it away.
Thanks,
Dave.
Tony. Welcome, everyone, and thank you for being here on this Tuesday afternoon. So this webinar is the main subject is going to be wrongful repossessions. We're also going to give you a legislative update on things that we know are going on in Washington, D.C. on the Hill from the Repo Alliance. In particular, we're going to address what Congress is saying about junk fees and data privacy. And we're going to move it along here quickly so that we can get to the things. One thing that we just want to let you know that we believe without a voice, there'll be no change. And we believe with a voice, bills will be passed to correct what has been broken. So the Repo Alliance is there for the whole industry, whether you're a member of any association or any professional association in the collateral recovery space. We are there to represent and help the industry. Marcel? The agenda today is, of course, what I'm doing, the introduction, and then we will move to the discussion of topics and then question and answers. And of course, in the closing, we will be sure that you all have time to comment and get your questions in there. And we thank you once again for being here. Next screen. I'm going to pass it now over to Mike Poplinski. He's the Vice President of Harding Brooks. He has some interesting information for us on wrongful repossession and what data is showing the insurance industry, at least what he sees about wrongful repossession claims. Mike?
Thank you, Dave. So first off, I always appreciate and enjoy speaking to this industry and educating this industry and working together, partnering with this industry across the board. Whether it's the national associations, the state associations, you guys individually, we're all here kind of, fighting the good fight, trying to make this industry better, because the better it becomes, everybody wins across the board. We're going to touch on an area that we all have been fighting for. I don't care which association, which state association you individually, regardless of insurance carriers, everybody's fighting this fight of wrongful repossession claims and how do we get our arms around it, right? Because auto liability is obviously a kicker right now where nobody's winning with auto liability from an insurance standpoint. But when you throw on top the wrongful repossession piece, that's a tough thing to swallow from an insurance standpoint, from your standpoint, from everybody's standpoint. So the areas I'm going to go over, right? Wrongful repo claims, are they on the rise? And specifically the trends, what's happening? Specifically what happened during COVID as our volume sank? What happened with these wrongful repossessions claims? Do they sync with it? Why are they trending in the certain direction that they're going, and what does that mean for us? And really, what's the breakdown of where these wrongful repo claims are coming from? Where's the root cause? And then how do we change these trends to favor us and put it in our direction? So I'm going to start off by kind of setting the tone a little bit and reading to you a memo posted by the Chief Operating Officer from Morgan & Morgan, which is one of the largest PI law firms in the country. This just kind of gives you the mentality of these attorneys that we're up against. So this is word for word from this guy, the CEO of Morgan & Morgan. Good morning, PI lawyers across the country. As we enter this new era, I want to make unequivocally clear that we will not be giving an inch to carriers ever again. Not 1 inch. Specifically, as a matter of policy, we will not be granting any extensions of any sort moving forward for any reason. They can figure it out or file a motion. Under no circumstance will we be agreeing to any continuances, discovery extensions, or requests to extend deadlines to answer complaints. It'll be a serious internal offense if we find any courtesies being extended to the insurance industry. No discovery extensions, no matter the circumstance. We might even want to help the defense attorney because we know them, and maybe even like them. But we will not, because they work for an enemy who is heartless and ruthless. Now, let me pause right there. The enemy that Morgan & Morgan is referring to is the insurance carrier, which represents you. So you and I are the heartless and ruthless. All right, I'll say it again. You and I are heartless and ruthless because we don't believe in paying hundreds of thousands of dollars to people for a free ride. That's how they're labeling you. That's how they're labeling me. Going back to the memo, how he refers to himself. We, Morgan & Morgan that is, work for the people. Again, no extensions for responses or complaints. If there are extenuating circumstances that would benefit our client only, please reach out for approval. As a blanket rule, we will be giving not 1 single inch. And he ends the memo in big bold caps, LFG. Now, most of you all know what LFG stands for, but those that are as naive as Renee, and I had explained to Renee, LFG stands for let's effing go, right? They're fired up to go after you, okay? That's what we're up against. That's the mentality of these attorneys that are coming after you. Now, a quick background. Why are these attorneys pushing so hard? Well, I'll tell you, because they're being funded by finance companies, okay? It's also known as litigation funding. In other words, they have a win-win situation. Whether they win or lose, they're winning. So what's litigation funding for those that aren't familiar with it? Well, it's a process of investors providing capital to plaintiff attorneys, which allows them to leverage a portion of the future asset, which is their winnings, right, to acquire immediate capital. So they get paid upfront, right to themselves, whether they win or lose. And if they win, well, then they'll share some of that money with these finance companies. And why are finance companies throwing lots of money at them? Because they're winning. So quick background, litigation funding was almost unheard of. It wasn't even part of the game not long ago. And when I say not long ago, I'm talking 2013, 2012, it barely even part of the game. But now is one of the fastest growing financial industry sectors, leading up to a $37 billion industry in 2019 alone. $37 billion this has turned into. And that's the mentality we're up against. So I kind of wanted to lay the foundation of here's where we are, here's what we're up against. Now, how do we go forward, right? So, Marcel, can you click the slide next, please? Perfect. So, for one, are they on the rise? Well, the actual is kind of surprising to me and kind of surprising probably to you. During COVID in 2020, when the volume plummeted, right, the wrongful repossession lawsuits relatively stayed flat, right? They didn't drop with the volume. Think about that for a moment. Volume was drastically down. Your revenue, your profits drastically down. Lawsuits are still coming in at the same velocity. Now, what's interesting is what happened in the next 2 years in 21 and 22. It's very interesting to me. Wrongful repossession lawsuits have actually not increased the last 2 years. They've kind of been pretty much flat, okay? However, where the lawsuits are coming from has drastically changed. In 2019, the wrongful repossession lawsuits that had invalid orders, meaning you, the repossessor, did nothing wrong besides pick up a vehicle that should not have been even assigned to be picked up, was about 20% of our overall total lawsuits. Okay, not bad. In 2020, that went up to about 24% of the total lawsuits we got were wrongful repossession invalid orders. here's the jump. In 2021, it jumped from 24% up to 43% of our lawsuits that we see were coming from invalid orders. In 22, up to 49%. Almost half the orders that we see are invalid orders. Now, majority of that were no liens. They're a lien loss. They're no lien loss. They should have no part of it should never have happened, right? That's a majority of these invalid orders. So if you really think, take a look back, it went from 24%, low 20s, right? Nothing that you want, but all right, we're under control to almost half of these orders. Now, Marcel, can you flip to the slide for me? Next one. So if you look at it as a repossessor, you're getting slightly better, right, in handling situations on repossessing vehicles with lots of problems. Why? Well, the volume hasn't really changed that much, except your percentage of it has gone down because the other percent has drastically gone up. Now, trust me, as much as I pat you on the back, there's a long way to go, and there's a lot of areas that we can get better on, right? And we are, and we're trending in the right direction, but we got to continue pushing forward in many areas. However, if you're given an invalid order, there's a good chance of you getting served a lawsuit, and it comes down to your contracts, right? So take a look at 21 and 22. So these are the 2 years combined. The 2 years combined, about 47% were invalid assignments. Of that 40%, majority were lien losses. Should never have ever happened, right? You kind of backtrack about, to 2012, 2013. This invalid assignment was about 20%, right? And more than doubled. And now we're at about half. So that's what we're up against. And every time you get an invalid order, and you obviously don't know about it most of the time, you're going to get sued. And it's showing, right? Why are these guys suing you? Well, let's face it. Everything's in their face. They have the best sales staff out there soliciting these people to bring in a lawsuit and say, hey, you don't do anything. You don't pay me a penny. I'm going to get you money. I don't care that you owe that debt. I don't care this happened. I don't care that happened. I'm going to get you money. That's what we're up against. So, Marcel, flip it back to the previous slide, please. One more. Yep. So, how do we really change this trend? How do we slow down lawsuits? Well, first off, I'll tell you, we're not going to slow down lawsuits, right? We can try to change where it goes, right? The increased litigation funding, the stance that these law firms are taking, it's only going to increase or stay where it is if we're lucky, right? However, our challenge is to move the bucket, right? Move the liability to the party who's actually at fault, right? We all know that, but that is our fight. That is our drive. That's everybody on this call is here to understand that and say, all right, now how do we go about doing this? Well, we've made a lot of changes, right? We've all been fighting this fight together. And in terms of equal and fair indemnification. So there's been a lot of progress, but here's what we found out. All these contracts, the ones that we've had success on, the ones that we have said, all right, we're going to make this equal and fair. Well, they individually made it for all their new onboarding people or you individually, but those that weren't in part of that conversation, well, you're still stuck on the old contract from 2013, 2015, right? They're not resending out to everybody. So one thing that I like to see everybody do, take note of this, right, is every year you need to inquire with your clients, and we'll try to notify you if we know, same with associations, but every year you need to inquire with your clients if they have a new revised contract. Because we've received many contracts, again, that have been changed, but yours was not. We get the lawsuit in and they're like, no, they told us we changed it. We're like, all right, great, send me your signed contract. And your signed contract still one from 6 years ago, 7 years ago, 10 years ago. It doesn't automatically change, right? Common, unfortunately, yes. We need to remember the event. It all goes back to the contract, right? It's necessary to get you guys updated contracts. I can tell you we've made so much progress lots to go, but we had so much progress. But I feel that probably half of the industry is still on the old plan, right? They haven't moved forward. Maybe you move forward on one client, but the other clients you have not. So take your contracts, look them over, send them to us, send them to whomever is willing to help you, right? And double check that date on your contract and double check that indemnification piece. It's not that we don't know what we have to do, right? But we have to kind of unite, be smart about what we're doing, and be very, very organized in terms of checking all the little ins and outs. One date, one word changes that contract, changes the outcome of these lawsuits very, very drastically. Clients and repossessors, you need to understand debtors of 2023 are not the same as debtors 15 years ago, right? They're educated. They know that they can kind of go turn for nothing and get something from it. Today's debtors are exposed to so much of that attorney advertising. They have the simple mindset of, I'm going to get something for nothing. And that's where they go. And that's why we've been very much involved in Repo Alliance at Harding Brooks and supporting this industry, because we've been making a lot of changes. And that's what I'm going to kind of turn it over to Marcel, and she can kind of discuss a little bit more of what we've done, what we're doing, and where we're going in terms of trying to help with this indemnification piece. Marcel?
Thank you, Mike. I think the biggest problem our industry faces is exactly what Mike was talking about. So our goal for Repo Alliance back from 2020, when we were in this firestorm, as David references it as, the repo moratoriums took precedent over anything else legislatively at the time. Not only in California, we had AB 2501. We knew if that passed, it would spread across the nation like wildfire. But we also knew in Washington, D.C., there were 5 moratoriums that we faced and beat, with Van Scoyoc as our lobbyist on the Hill. I think as far as the reverse indemnification goes, we were told by Van Scoyoc very transparently, this is something we can attack down the line. This is future after the pandemic. We're now through the pandemic and working on that legislatively. And reverse indemnification is something that is so harmful, not only for the consumer, for our industry, for insurance coverage on many levels. So our goal long-term is to get rid of reverse indemnification and for the actor who did the bad act to carry that liability. That is our long-term goal. For those of you that don't know about Repo Alliance or how it was started, but it was started about 3 years ago with Mike at Harding Brooks, ARA, CalR, and Texas ARP, knowing that we had to do something. We knew that there were moratoriums on the horizon that were going to last 2.5 years. And if they went up for sunset review, they would even be beyond that 2 to 2.5 year mark. It would have been indefinitely or just modifications that would have hurt our industry greatly. And I think to keep the checks and balances in place for lending and for Mike and other insurance carriers in this industry, we really needed to come out full force, boots on the ground, and fight all of the moratoriums. And the reverse indemnification piece was put on the back burner, but now it's on the front burner. And our goal is to help everybody that it's hurting. And I think if we don't get it fixed, I don't know if we'll all have insurance coverage. Mike, you can vouch, for that. And I think as far as our industry is concerned, we can't afford the lawsuits, right, wrong, or indifferent. Litigation is very expensive. It doesn't matter, like I said, who wins, who loses. It's a costly involvement. And I think that we need to get rid of it altogether as far as the reverse indemnification goes. David, did you want to add to that? You're still muted.
No, thank you. I thought you did a good job on that. We are, so basically, I'm going to add just one sentence or two. So, in the middle of the firestorm, the moratoriums, that's what we were in a defensive posture on the Hill, the Repo Alliance. The whole industry was on a defensive posture, just trying to stop the inevitable that was happening. And of course, some industries, as you well know, saw it happen to them a lot worse than us as far as renters and things like that, the landlords. But now, thankfully, we've been able to, at the current time, we're not in the middle of a moratorium firestorm or anything like that. There are things happening that we're watching, but reverse indemnification, we've now been able to go on to an offensive position instead of always playing defense. And we'll talk more about that and later on in the presentation.
David, did you want to move on to junk fees and how
Sure.
they're related?
Sure. So, you know, as we said, the Repo Alliance through our lobbyist, Advanced Skoyak Associates, one of the keys is that, you know, things happen in Washington, D.C. that most people don't even know about. For example, really it doesn't have to do repossessions, but right now in the last 3 weeks of Congress are trying to pass a defense bill. And I don't know if any of you realize that senators are trying to add to that defense bill over 1,000 addendums. That's a true number, 1,000 addendums. Many of them have nothing really to do with defense, but they sneak them in there. And that's why it's so important that this industry actually has someone representing us and watching and letting us know what's going on. So on June 8th, the United States Senator John Hickenlooper, he is the chair of the subcommittee on consumer protection and product safety and data security for the banking committee. He held a hearing on June 8th about these subjects. And again, I'm sure very few Americans knew that Congress was gathering information from people to make definitive decisions that would affect our industry and the auto finance industry. And one of the things that Congress is very interested in this year is junk fees, surprise fees. And of course, there's a lot of areas that this comes into, not just the auto finance area, but credit cards, real estate, everything, where a lot of the fees are not explained to the consumer and then are added on, and they feel they can do dramatic harm. The numbers that they've come up with is that 85% of Americans recently have encountered junk fees in all areas of their life. Of course, consumers are frustrated, they're angry. We suffer from that because, as we all know, there are junk fees that are added into the repossession process. In the auto finance world, one of the things, of course, Congress is saying the fees that are added on the front end of an automobile loan, which they feel dramatically endangers consumers' ability to pay for that automobile, as well as fees that are added on the back end if something goes wrong by the forwarders, facilitators, fees that are not clearly explained in any contract. And of course, it has caused us an issue because in our line item billing, there are fees that we need to be able to charge that now you're starting to hear banks say, well, it's not in our contract, so we can't give it to you. And we are fighting dramatically to be sure that that does not happen, because it's important for us to be able to work at cost. And there are special circumstances that are involved. And they basically are hanging their hat on something that at one point in time we were covered under, and now contracts have been changed, and most of us, of course, aren't aware of it. The contracts with the consumers have changed. We were not aware of it, and now the banks are using that contract language to get out of paying us line item billing and things like that. So we're working very hard in discussion. We've had 2 meetings in the last week with senators on the Senate Banking Committee. They are once again we've reached out and had meetings with them, and they consider the Repo Alliance as a good source of information. Our biggest job has been educating them. We've had great conversations on junk fees and how to work around that. And also our major conversation on it is how to protect us and realizing that our line item billing is not junk fees. Marcel, let's flip.
Marcel, you're muted.
Sorry, guys.
Okay.
So I know we've got Matt with us. We have one more topic, David, for you, and then we'll switch to him if you
Yes.
want to run through the data privacy quickly.
Sure. So data privacy for all of us, you all know, this is not a new subject, but it has gained a lot of momentum in Congress and in the Senate Banking Committee. And of course, it's also, believe it or not, addressed in the defense bill because they have had some issues with what we'll call secular is the wrong word, civilian applications affecting the security of the defense system. But for us, this has been around. We became aware of it probably 4 years ago and maybe 5 years ago. And we have been talking about it, addressing it. And of course, as we well know, the lending institutions pay this fee already. They, at the current time, it comes out of the budget in the remarketing budget. However, because of where the action takes place, what we are working on is for them to understand that this is something you want to have your privacy defense system in place at the point of earliest intrusion. And of course, that with that comes a additional revenue stream, but one they're already paying. And that needs to be with us. And Congress is very interested in protecting the consumer at the earliest intrusion point. Our job is to be sure that we're educating them, and we are. And Matt can talk more about that, on that this is something that has a cost to it. It's something that's important. It's something that they understand how we, as the collateral recovery industry, plays a vital role in protecting the consumer, as we do in so many other ways. That we have educated Congress that we are not the bad guys. We are the person who is the first line of defense for consumers, and we're working. What's the future hold? I can tell you probably within the next 2 years, Congress moves slow and then sometimes it moves fast. But by the time they work this all out, of course, they'll try to sneak something in on us. But by the time this, all works out, this is going to become a key issue in the auto finance world. And it is going to affect us dramatically. And we will be here to let you know how it goes. Right now, again, it's not new, but just recently it's coming onto the forefront. Everybody's known about it. And again, this is where Congress moves slow. One, because gathering information takes a long time, and they are now moving it to the forefront. And we had 3 senators on the banking committee list this as one of their major concerns for this year. And so we are watching this very closely for you and taking action and educating them. And again, we've had 2 calls, and we have another call this week with the 3rd person on the banking committee. So, when you start having calls with 3 people from the banking committee, something's up. And we're there to watch and take care of it. Marcel?
Matt, Hank, Dan Skoyak.
Sure. So thank you so much, everybody. First of all, thank you to everybody at ARA and the Repo Alliance for hosting this and for having myself participate and really to just give a little bit of information about what we've been doing in federal activity as it pertains to the federal priorities for ARA and the Repo Alliance. It's a lot of hard work from people like Marcel and Dave and Mike, who've really been there for a very long time, taking care of both the internal process of making sure that priorities are identified, and then the external part of how we communicate with Congress, with executive agencies, so not just FTC, but CFPB, a lot of federal agencies that have skin in the game when it comes to issues that matter most to ARA and repossession agencies across the country. So just a bit of background. So myself, Matt Hinken, at Van Scoik Associates, as well as my colleague Jennifer Lotred, who's the president of VSA. We've been working now with ARA for about 3 years, and it's been a really interesting evolution where initially, as earlier, I think it was Marcel who was saying earlier, that initially we were really in a position of defense as we were battling against a lot of the moratoriums that were being imposed by Congress. And we successfully defended the industry from a potential imposition of a repossession moratorium, which would have been, obviously devastating to the industry. And so we saved that off. But as we emerged out of the pandemic, after that first year or so, we really started to move into broader long-term priorities that matter most to ARA and to the Repo Alliance and to all of you on this call, some of whom we've met before and a lot of whom we hope to meet in the future. But I think really of late, Dave and Marcel had been identifying, and Mike had been identifying that really a lot of our work has been focused on reverse indemnification, which is that in order to make an auto finance industry work healthy, you need an alignment of the responsibility and the accountability, which is that when a player takes an action, that they potentially face consequence for those actions. And certainly repossession agents, I think we've communicated to Congress extensively that we are prepared to accept responsibility for our own actions. Whether it's damaging a car or something else, we can accept that responsibility. It's difficult to maintain a lot of important parts of the industry when you're accepting the responsibility of somebody else's actions. And so this is really one of the central messages that we've been communicating when it comes to reverse indemnification. We've met with, I think I checked earlier, 60 different House and Senate offices on this issue. And most of them are on the Senate Banking Committee as well as the House Financial Services Committee. So those are the committees that really have jurisdiction over finance issues. But we've also been meeting with the judiciary committees of those two chambers, which have jurisdiction over antitrust issues related to monopolies. And a lot of the people there saying a lot of the activity that we find is actually more reflective of antitrust abusive practices than they are necessarily with solely kind of a financial industry related topic. So, we go to these offices and we're meeting with everybody. As you know, as most of you probably know, the Democrats control the Senate right now and Republicans control the House, but in both chambers, they have a razor thin majority. And so when you have one chamber having the Senate, one party having the Senate, one party having the House, it's difficult to get legislation done. So a lot of times things are moving slow. But as Dave said, Congress works really slow until it doesn't, and that's when it moves at kind of rocket speed. And we always have to be prepared for that. So we're meeting with Republicans and Democrats in both chambers, communicating. A lot of it is simply Repo 101, which gets to the larger auto finance industry. And a lot of the staffers who are professionally trained, focused on financial issues, are not very familiar with what is going on in the auto finance industry, and certainly not necessarily with the repossession profession and what ARA advocates. So it's a lot of education. But when we are educating, we're talking about reverse indemnification. We are talking about, data privacy. We're talking about junk fees. And what we are seeing is that there's a really strong receptiveness to what ARA is saying, that people understand that with a lot of our counterparties, we are facing a situation where it really isn't in anyone's interest, except for potentially one organization, to have the the legal liability for bad actions to be placed on a party who's not responsible. For Democrats, we've kind of been focusing more on the consumer aspect of that, which is that any consumer protection laws are kind of worthless if the person that actually is in charge of it doesn't face any legal liability necessarily for their actions. And for Republicans, we've really focused on the health of the auto finance industry, which is that if this continues, it really distorts the industry and makes it harder to access credit, harder for, and certainly hard on families. Looking at some of the raw numbers that we talked about earlier, Mike mentioned that basically half of all wrongful repos are due to no liens, situations where we're trying to communicate to Congress why these are bad. That really is a downward spiral that really impacts American families negatively. And so our job has been to educate, not just on the industry, but on some of these specific topics. And we've had really good discussions. I mean, we've, just the other day when we met with Congressman Scott Fitzgerald he's from the suburbs of Milwaukee, and his staff was actually, asking us to, give legislative language on potentially what might be able to fix this problem, because they are hearing from their constituent staffers. The way that Congress works is that every congressman or congresswoman or senator, they're going to have staff in DC advising them, but they also have staff back in their home states and home districts working with constituents on problems. And there are people who they're going to have their car repossessed wrongfully, I might add. They'll call their congressman and say, hey, what's going on? I've been paying my bill, every month, and this was a wrongful repo, or it might be something where they had been delinquent, but they had reached some sort of payment agreement with the lender. They call their congressman. So we need to educate them, because they hear about this and they need to be able to adequately explain to their constituents what's going on. And in this case, as we're seeing wrongful repos, we're seeing repossessions generally go up. But on wrongful repos, we need to explain to Congress why it's going up and provide some sort of solution to really reducing wrongful repossessions and ensuring that both on a labor level, which is that nobody wants to be wasting the time, energy, and labor conducting a wrongful repossession. It's not good for you guys. It's not good for anybody. And takes you guys away from doing, legitimate repossessions. So all of this really comes back to a lot of work that we're undertaking regarding reverse indemnification. With that, I know that we wanted to save about 20 minutes at the end for questions and answers. So I think I'll maybe stop there and field any questions that you guys might have specifically about our congressional outreach. I know David, Marcel, Stephanie, Mike are all very much involved in this. And so I'll turn it over to you all to field those questions and see how we might be able to answer them.
The first question we have, Matt, is regarding clients holding up their indemnity in cases resulting from a lien loss. Mike, this might be more appropriate for you.
What was the question now?
It says, I have a question regarding clients holding up their indemnity in cases resulting from lien loss.
I guess I'm not exactly understanding the question. I guess I would interpret it. They're dragging their feet on stepping up and covering you. Yes, I can tell you 100% they will. That's your lenders. I don't really know. From a standpoint, it's really kind of come down to your relationship with your the lender that you're working with, the representative that you kind of have contact with. That'd be you and them getting on the same page. But yeah, I'm sure they will. Their attorneys aren't going to want to extend coverage. I think I've seen it once or twice out of the thousands we've seen.
So, Mike, are they expecting then us to carry the water in that regard if there is the reverse indemnification?
They would 100% have it in their contract that whether you're at fault or they're at fault, you're taking it on. And that's not everybody, but that is the majority, unfortunately.
Our
Mike.
next, go ahead.
Hi, Mike. It's Kevin, TFS Recovery.
Hey, Kevin.
Okay, so we started this in '92, and what everybody said was about correct. Post-COVID, people are getting a little smarter with lawsuits and costs that go out to the banks for this equipment we're repossessing. We do have the reverse indemnification letters that are issued with every order. We have 2 cases that are ongoing now that I have not submitted to insurance that we actually have paid out of pocket for our attorney costs. We're about 100,000 into it now, in which the indemnification states that they're going to pay any and all fees, expenses, services performed in connection with, and notify us if there's a repossession should not be carried out. and agreed to pay all those costs in case of a lawsuit. Yet we're 2 years into both of these lawsuits and they're both still ongoing at my dime. Is there case law or anything that you can speak of that can be used to get these banks to get off their, and get these things being paid for?
It's a good question. I would tell you every state has some different case law in there. Absolutely, it's going to be coming down to attorney versus attorney and who wants to push each other and who wants to budge. And it's a long, drawn out process, and that's very unfortunate. I'd have to look at the case individually, where it's coming from and really what's going on with it, kind of answer that appropriately. There's always different ways to speed things up. Yes.
I'll get these over to you to take a look at them, but that was my primary question. I don't know if anybody else has had the same issue to where they've recovered something where the bank has had either a lien loss or have to pay off or settlement for an asset, and then they've had an agent go pick it up and then it gets into a lawsuit. I'm sure it happens more than just us.
Our next question is, why not just tell the repossessors to verify the lien prior to hitting the street? I can go ahead and answer that, Mark, and tell me if my answer is sufficient. So a lot of states are privacy states. They don't allow this information to be public. For us, California is a prime example, and I know many other states, they don't allow a lien scrub to be done. So that could be the reason. And also, if the lien holder in our state is issuing a repossession, they actually have to be the lien holder of record. I don't know how many other states in the nation have that same law, but we do have that law in place. So they're not allowed to issue a repossession unless they are the lien holder of record. And in your state, Mark, maybe it's less, I'm not sure if you can run it, if it's available to you and how expensive it is, but that could be expensive when you're receiving, hundreds and thousands of assignments every month. You can unmute, Mark, because you're muted currently. Hey, Mark, we can't hear you, just so you know.
Can you hear me now?
Yes, you're good.
Actually, 42 states let you conduct a real-time lien verification. And quite often, as many of you know, you'll have companies like Title Max who will just put the title in a drawer, and that vehicle will get impounded and then sold at auction. So whether or not the lender is allowed to send the assignment, those assignments are sent. And I'm under the understanding that if you're able to spend $2 or $4, whatever it is, like I said, available in 42 states, that's a lot less than fending yourself out of the lawsuit. And I just think that perhaps the simplest way to get that information out is just tell people, go ahead and verify the lien. Spend a couple of more bucks. Thank you.
You're welcome. Next question we have is, I received an invitation from CFPB to apply to be nominated to their advisory board for the collection industry. Does Van Scoyoc feel this would be beneficial to pursue? And that's from Leon Scroggins. Leon, was that on behalf of RSAG or just as an individual? So Matt understands the question. Was it in your capacity as an insurance carrier? Are you able to unmute him, Tony? Leon Scroggins? If not, you can type the answer in, Leon.
Can you hear me now?
Yes.
It was as an individual.
So Matt, do you want me to repeat his question?
No. I get that entirely, and I think that's great. Before I answer your question, I think it is really important to talk about what ARA and VSA have been able to do with CFPB to this point, which is that I think we've earned a lot of trust in developing a relationship to help educate them. I mean, the individuals in the auto finance department of CFPB are very familiar with the industry, but they certainly require on the ground experts, people like, everybody on this call, to provide them information about what is going on, in, day to day, what the larger ramifications of policy end up doing to the repossession industry. And so I think that when they have questions, they do reach out directly to ARA, to a lot of the folks, Dave, Marcel, Mike. I think that the conversations that we've had have been very constructive with CFPB. So to your question, I think that would be a really good opportunity to be a voice, to help formulate what CFPB plans to do in addressing some of these issues. So back in, I believe it was February or March, they issued a compliance bulletin looking at a number of issues regarding wrongful repossessions. And I think that they looked at some real problems, but I don't think they fully understood. I think wrongful repossessions is a perfect example. Is that I think if they fully understood the correlation between wrongful repossession leading to an increase in reverse indemnification leading to wrongful repos, I think being able to have a voice in that discussion as they are putting together their policy, I think be really valuable. And I would certainly recommend that, maybe a periodic call, with maybe a quarterly call with some of the VSA, ARA team, just to kind of make sure that we're all on the same page, that as we're doing congressional outreach, that we're aware of what's going on with CFPB and vice versa. So I think that's a great idea, but I would love to hear what the rest of the team thinks about having some of our good members participating in an advisory position with CFPB to help formulate that auto finance, their auto finance activities. I don't know if Dave or Marcel or anybody wanted to chime in, but I think it sounds like a great idea that could help everybody.
I'll just say that I think that the governmental bodies, when they have a number of reasonable people communicating with them, one, it helps to have, I'm sure the message would be unified. Leon, you've been in the industry, for a long, long time. And so being able to communicate with them never hurts, because they do, one, like hearing from various aspects of the industry, so that they feel in their minds that they've garnered information across the board. So I'll just say that a unified message coming from well-versed individuals is always a good thing in the government and dealing with governmental bodies.
Mike Puplinski did answer a question that was in the chat, you guys. It wasn't sent through the Q&A. It asked specifically, can the insurance companies insert language on the binder that states coverage does not include wrongful repossession coverage where the insured is not at fault? Do the client contracts need to be signed every year standing up in a litigation case? And Mike answered him. Can you guys all see this in the group chat?
I can touch on it, Marcel.
Yes, please. Thanks, Mike.
The one question was, do the client's contracts need to be signed every year for it to stand up in a litigation case? And the answer is no. You guys have been working off contracts that are 3, 5, 10 years old. My response was the contracts do not need to be signed every year. However, it's a good best practice to review your contracts every year to see if anything has been updated that could help you, benefit you. And you see many times, as I stated earlier, clients have updated their contracts to benefit you, to benefit the industry, which is a great thing. However, you're still working off the old contract. You got to get that new signed contract, because when push comes to shove, when a lawsuit comes across, they're strictly going off your last signed contract with the lender. They don't care what they have with somebody else. It's you and them binding the agreement. And you just got to make sure you're on the most recent best one for you. And then
Mike, too, and that, so the reverse indemnification more that you're seeing, it's coming from more of the what I've experienced in our state with Brandon Block and Alex Trueblood. They're the attorneys you were talking about earlier in the memo that you read. The reverse indemnification is coming from the brokers and the forwarders in my state anyway. I don't know if that's something nationwide, or is it predominantly from the broker forwarder or title loans as was stated earlier, from Title Max, I believe it was. Not the direct lenders, not the larger lenders and banks in the space.
Yeah, most of the direct lenders, not all of them, but most of the direct lenders have really wanted to work with you guys and have done a good job in terms of making their contracts fair and equal for the most part. And let's face it, I don't know the last one I heard was somewhere around 74% of the assignments are coming from forwarders, right? And that's where the lawsuits are coming from, majority. One more question I got in the chat box, if you see it, I don't know, was can't the insurance company just put in some language that there's no coverage if it's an invalid assignment? Yeah, sure. I mean, we could do that, but it only harms you because the contract that you're signing is between you and the lender, nothing to do with the insurance carrier. So we could stop and not pay, but they're still going to come for you to pay, right? It goes off the contract. Honestly, whether you have insurance or not is irrelevant. Whether you're paying or the insurance company's paying, somebody's paying. It goes by the contract.
Are there any more questions? I don't see anything in the chat box. Mike, I think that last one might have been for you. If you can see it.
Let me see. The 46% of lawsuits are because of an invalid assignment. It is a good habit to verify every lien prior to hitting the streets. Simply put, it's the easiest solution. Yeah, I can't disagree. That's time, money. However, it's time, money when you have to deal with lawsuits. So yes, I agree. Good comment.
David and Matt, did you have anything else you wanted to add?
Hey, Mark Lasik, you said that 42% of the states, or 42 states allow you to do the liens. Do you know which states do not for sure? That you could just tell everybody on the screen? You're muted, Mark. Unmute yourself.
Well, I think one could just go to ADD123, the website, and they have a list of the 42 states that allow you to. Of course, California and Pennsylvania are one of those that won't let you, but just go to ADD123 and they list the 42 states that allow you to do a real-time verification. And just so you know, I had a conversation with the fellows over at TLO at the NARS conference, and they had mentioned that their information in reference to lien verification is probably anywhere from 2 weeks to a month old. So, I'm not saying it's real time, but even getting something 2 weeks to a month old could be helpful to keep you out of the courtroom. Thank you.
Thanks, Mark.
And I will just, to Marcel's last question, I just want to thank you guys for giving us the opportunity to discuss this. I think it's really important to share with ARA membership broadly the good work that this team is doing to advance the ball, both in Congress, but also with federal agencies to address a lot of the issues that I know are front and center for you guys every single day that you guys are out there doing the good work. So I appreciate that. And I really do enjoy working with everybody. I know Jennifer LaTourette also, we really enjoy working with everybody. So for everybody that we don't know, we look forward to hopefully meeting you guys soon, but we want to let you know that it really is something where your voice is being heard in Congress among the people that make these types of decisions. So we're working that, and I'm glad we had an opportunity to discuss that today.
Thanks, Matt. Mike or David, anything else before we wrap up? We have 2 minutes.
I'm finished. Thank you, everyone. It was a pleasure. I hope you find it useful. God bless you and have a great day.
if anyone has any questions or wants to reach out individually, give me a call, always open to discussing anything individually or as an industry. We're in this together. We're here to help every association out there, every individual member out there, because collectively, what Repo Alliance is about is to help this industry. And the better this industry does, the better everyone on this phone call will be. Appreciate it. Thank you.
I concur with Mike. Thanks, guys. Have a good day. Thank you.
Thank you.
Thanks, everyone.